an outgoing EAW procedure towards another EU state. The Italian judge drafts the EAW based on the standard form. It's actually an annex, which you'll see when you essentially of the judicial authority of the requested member state. Or, well, remember, we've talked about Interpol, the codes, and so on and so forth. It is entered, it's transmitted into the SIS system or SIS2 to Interpol. This is done with the ministries, with the assistance of the Ministry of Justice. So in practice, if the public prosecutor, the Attorney General knows where a person subject to an EAW is, they generally first contact their counterpart in the receiving country. But in judicial practice, if there isn't a particularly compelling interest in an individual, registration in the SIS is preferred. And then whoever catches them first, even during a simple routine check, arrests them. And that's when the procedure, begins. So the requested state carries out the arrest, as I was saying, and brings the person to a hearing before the local judge. Now, on the other hand, let's look at the opposite phenomenon, the incoming EAW. That is when another European state from the European Union requests a subject who is on our territory. So the EAW in this case is received by the territorially competent court of appeal. The person is arrested and is subject to validation and an identification hearing. If the person, and this is fundamental and it's a mechanism that is completely identical to extradition, consents to the surrender, the procedure is obviously simplified. In just a few days, they are sent to the requesting state. In the event they don't consent, the process moves to a hearing on the merits of the surrender within 60 extendable days. So those are the 60 days that the law provides for, let's say, the decision. There are mandatory grounds for refusal of the surrender. One, of course, is that of dual criminality. I'll make a quick aside. This lesson is important to me because while it's true we've covered these topics, it's always good to have a refresher on the foundational criteria, the foundational regulations, and the foundational principles of the entire subject matter that we handle. That is, extraditions and the European Arrest Warrant. So, what are the grounds for refusal? Well, dual criminality. The subject of the EAW does not constitute a crime in Italy. You're asking for the arrest of a person for a crime, or rather, for an act that is not actually considered a crime in Italy. This is a mandatory ground for refusal. If the crime is time-barred under Italian law, so I must really stress, in the context of legal defense, always carefully check the title of the offense and the dies a quo for calculating the start of the statute of limitations. It's a classic defense argument. If the person has already or previously received a final conviction for the same act in Italy, so in cases where this is also, as you may know, a mandatory ground for refusal. Then there are the optional grounds for refusal. So what are they? For example, the person is an Italian citizen or resident in Italy, and the state offers to carry out the sentence in Italy. That is, it can happen, and often does, that for reasons of sheer practicality, the execution of the sentence is granted in Italy, for example. This is an incredibly useful thing, precisely because we, especially due to the presence in our legal system of the Gozzini law, we can use this in particular, let's say, legal loophole of executing the sentence in Italy, fundamentally, to allow for example, the convicted person to not serve that sentence. I mean, in Germany, there's no Gozzini law. You do your time in prison. Same in France. So if essentially this happened it actually happened to me just a few days ago. A young man from Naples arrived at Paris only with drugs. then an arrest warrant was requested because he had been, convicted, then released, various events. And with 3 years to serve in France, Italy did not surrender him. And this young man will apply. In fact, he has already applied to the supervisory court, and so he will get an alternative measure. So this optional ground for refusal is a wonderful tool from the defense lawyer's perspective. Another optional ground for refusal is the fact that the crime was committed in whole or in part in Italy. The issue here is that of a remote offense, especially a remote offense, right? Think of scams, think of international misappropriations, think of digital scamming. The last case of optional refusal is when, for example, the crime is covered by an amnesty or, in any case, by a clemency measure under Italian law. What are the consequences of the surrender? Once surrendered, the defendant can be tried exclusively for the facts indicated in the EAW. And this is the famous principle of speciality. We talked about it in the second lesson, meaning I surrender him to you, but you can only deal with the detainee in relation to your request, not for other matters. It's extremely important. Barring consent from the issuing state, but the founding principle of surrender and also parenthetically of extradition is this principle of speciality. Furthermore, if the surrender was obtained for the execution of a sentence, the Italian authority cannot modify or worsen the sanctioning regime compared to what was established in the EAW. Okay? This is obviously a fundamental principle precisely because it pertains to the certainty of the sentence. It's a constitutional principle. Some critical issues